14 to these other entities is, as you said earlier, an element of uttering and publishing, correct?
Yeah.
Okay. And the question I've got for you is, you could conclude from this, could you not, that Sean Flynn mailed out this package to the Senate and to the Archives Office?
I would say it suggests that.
Okay. And that would make him an aider and abettor in this case, wouldn't it? He sent that?
I think you have to take not just this bit of information, but all of the information.
Okay. So understanding all this would make him an aider and abettor in this offense, wouldn't it?
I think it would be evidence suggesting that he assisted, participated.
Okay. Now, in regard to how the charges arise in this case, you indicated earlier yesterday that you prepared an affidavit of probable cause about each of the defendants in this matter, right?
Yeah.
Okay. And then you submit that to a judge seeking a complaint signed by, or a warrant signed by the judge, right?
Yes.
Okay. And you did not do that in regard to Sean Flynn, right?
Yes.
Okay. In regard to the affidavit that you prepared for each of the defendants in this case, I think yesterday you said that you prepared paragraphs 1 through 37. Is that what I understand?
Sounds about right.
Okay. 38 through 45 were prepared by a lawyer, correct?
Yes.
At the Attorney General's office, right?
Yes.
And then you took that, signed it, that affidavit, correct?
Yes.
Attesting to whatever was in this was true, even though the lawyer put in additional paragraphs that you didn't have in your probable cause affidavit.
Yes.
Right? Okay. No. In yesterday's question, Mr.
Hi, Clay. I think the timing is off. I apologize if I'm responding to things really late.
Hawaii,
I apologize.
the facts that occurred in that case. Remember those questions?
Yes.
Okay. And I think one of the things that you said that was important to you was the fact that the electors were both the Republican and Democratic slates had met together. Is that what your understanding of the facts were?
Yes, there was several things that were different. Yes, they met together.
Okay.
There was a recount, and the margin between the two parties in Michigan was 150,000. In Hawaii, I don't remember what the margin was, but I remember it was much smaller.
Okay. In regard to the meeting together, did you interview in your investigation? Did you interview Governor Whitmer? No. Therefore, you don't have any evidence as to whether or not the governor had invited any of the Republican electors to be present during the December 14th, 2 o'clock meeting at the Capitol.
Could you repeat that?
You don't have any evidence that the governor had invited any of the Republican electors to be present during the counting, or I should say the vote that occurred on December 14th at 2 o'clock in the afternoon.
That's correct.
Okay.
Yes.
Going back to your affidavit of probable cause, in the paragraphs that you prepared, at the point that you had completed those 37 paragraphs, in your mind, that was sufficient for the court to authorize charges against the individuals in charge in this case? Yes.
Yes.
The Attorney General had added additional paragraphs. So Assistant Attorney General, right?
Yes.
Okay. And so in regard to signing this affidavit, you relied on the lawyer's advice about how this affidavit should look and when you signed it. You relied on what they told.
They recommend the charge.
Right. Okay. And so you relied on their advice of recommending charges to sign this affidavit.
Yes.
Okay. We talked about the fact that you had prepared a search warrant for records from Facebook or Meta. And you also prepared other search warrants in this investigation, correct?
Yes.
And one of those one of those search warrants that you asked a court to authorize were for records from Give, Send, Go, correct?
Yes.
Okay. And in your request for records, in that search warrant request, let me back up. In getting a search warrant, you prepared the actual search warrant, correct?
Yes.
And
Forget, sign, go.
Yes.
Yes.
Okay. Give, Send, Go. And the affidavit in support of that search warrant request, correct?
Yes.
Then you turn both of those over to a judge who signs the search warrant, provided that there's probable cause in the affidavit, right?
Yes.
Okay. And in that search warrant, you were seeking not only the records of accounts that were, apparently there were 2 accounts with Give, Send, Go that you were looking for information on. Is that right? One accounts with Give, Send, Go.
There was 2 accounts. There was one account for each defendant that was on there.
Okay. In that regard, then you have to list in your search warrant all the things that you're looking for, right?
Yes.
Items that you want to seize.
Yes.
And information that you wanted from Give, Send, Go included the account information, and I should say bank account information of individuals that had donated money to these accounts, correct?
I don't recall specifically that information.
All right. And if you, well, can you think if you did, let's put it this way, you did ask for the bank account information of the donors to these accounts, and you, what information that would be relevant to your investigation in this case would that have provided you if you had the bank account information of the donors?
So there is a lot of information that I'll request without referring to the affidavit itself. I don't recall. As I said yesterday, a lot of that information is to show ownership to the accounts. The accounts can also, they can be created, they can be edited, so the statements that are made in the accounts can be edited as well. So like, for example, in social media posts, they can be edited and you're looking for an audit trail of the edits. So again, I said yesterday, I was focused on the statements. The associated information of also asking for is to show ownership of who created the account and to connect those statements or the account holder with that information.
All right, so if I understand how this works, Give, Send, Go is, if I wanted money from people, I would set up an account with Give, Send, Go, and then send out requests for money to people on the internet.
Yeah.
Okay. And then if someone reads that and decides they want to give me money, then they will authorize a transfer from their bank to Give, Send, Go in my account at Give, Send, Go. Is that how it works?
I don't know specifically the
That was the worst
the
explanation
procedures that Give,
possible.
Send, Go has in place. If you're asking me that, the technical procedures of
No,
how they route the money.
All right, can I just think of it this way? I have an account with Give, Send, Go that people donate money to. Is
Yes.
that right?
Yeah.
Okay, all right. Those people that donate money, Give, Send, Go, is it your understanding, records who gave money and how much?
Yes,
Okay. And
That's
can
actually
you
a
think
different
of
question
why
than he
would you
asked.
want to know the names of the donors to the, or the bank account information of the donors, as opposed to just the owner of the, my name and the Give, Send, Go account? Why would you care who gave me money?
that's not a focus. So Give, Send, Go uses a third party to handle their financial transactions. That's what I learned on the return information.
Okay.
So I did not submit a search warrant for the third party financial institution.
Right.
Because I'm focused on the statements and how those statements are tied to the defendants and to show ownership of them, you know, the statements that are made in there. So that's the information that I'm focused on.
I'm asking open-ended questions here, and I appreciate that. But I'm just trying to figure out, why would you want to know the names of the donors?
I just explained. I can explain it again.
To show
So
ownership of
to show that the ownership of the account. There's, as we asked for information.
Show it wasn't money
I'm trying to
laundering.
connect the person that made statements on that account to the people who are may have edited it, may have created it. I'm trying to show ownership there.
ownership of the, back to my example,
So that
you want how much money is in my account that Give, Send, Go.
I'm not concerned about the amount of money that's going into your account.
You want to show I own that account.
I'm concerned and focused on who owns the account and the statements that are made.
Okay, by the subjects of your.
Right.
Well,
Give, Send, Go
doesn't
uses a third party to handle donor, you know, to handle those financial transactions. They did not have access
I understand.
to that information.
But you did ask for the information of the names of the people that gave money to my account. As an example.
I don't recall them.
I had asked you earlier about notes that you kept
Hi,
while you were
Kathy.
doing your investigation. You said that you don't have those anymore. I'm talking about personal notes.
Yeah.
And so I assume you said you don't have any of them anymore. Is that right?
Well, and with the exception of this past week, I have notes that I used to create for this exam.
Okay.
So, but going back, I don't have any of the notes. The notes are transcribed to a report, and then shredded.
Okay. So is that the normal course?
Really?
Your
Like source
any
notes are
investigation,
shredded?
notes are destroyed
It's,
prior to someone
That's
being
kinda-
charged.
That's kind of weird, isn't it?
yes, a
Isn't that kinda
handwritten
weird?
notes that, yes, I
don't
take that
know.
information, transcribe it in a
That seems
report,
weird.
and then
Seems weird.
destroy the evidence.
Okay. So to finish that, you said they're transcribed. What do you mean?
I review what I've written down and then type that out.
Okay. You type your police report using your notes to refresh your memory about what somebody said or what you found.
Yeah.
It's not verbatim transcription in your notes to your police report.
It's close. You know, I use the notes along with the audio recordings. If I have those as well.
I don't recall, you have prior law enforcement experience before the AG's office?
Yes.
Where was that?
I worked at Meridian Township Police Department in Beverly Hills Public Safety.
Okay. And in the fact that you shred your notes that you were just talking about, is that something that is a policy with the investigator's office of the Attorney General?
No,
Is that your own personal method of handling that?
I do those notes confidential, and I don't want them to be lost or misplaced or anything like that. And over 26 years, I would have an awful lot of filing cabinets in order to accommodate all those notes. So the information is transcribed, as I said, down on the report, and then that information is shredded.
A report that you prepare yourself, right?
Yes, anything that has my signature on it.
And in regard to those, I'm not saying keep your notes going back to Beverly Hills Public Safety Department, but what you're saying is you don't even retain your notes to the point where someone is charged with a crime and has to defend themselves.
Again, I said to retain notes over 26 years as an investigator would require a lot of filing cabinets. So I hold on to the notes until that information is put into a report. That report is approved by my supervisor, and then I no longer need it.
Why are we doing this? Because it's like,
No. So what you're saying
where
is
are we
you don't
going
even
with
hold,
this?
I'm not saying hold it for 26
is he
years.
just trying to
No, I
You don't
discredit
hold them
the
until
investigator?
even
I
until
don't
a case is
understand.
charged. You don't keep them that long.
No, once the report is approved,
Then you shred them immediately. Close to.
close to.
Within 24 hours? Within 12
1
hours?
second.
Do you do it right after you finish typing? Do you do it when you hit send? When do you do it? Which shredder do you use? How close is it to your desk? How often is the shredding removed from your office? I don't know. This is dumb. This is dumb. And this is just one lawyer, right? So is there 8 lawyers? Because I think this is for 8 defendants. Maybe they think he withheld the notes. I guess. Exculpatory. Is this a Brady violation? Is that what we have? We have a Brady violation.
Thank you, Judge.
I think he must be Michelle Lundgren's lawyer.
Pulled up the
I'm
search
assuming.
warrant affidavit for
They started
the consent
earlier than
bill.
they said they were going to. Made me mad.
And would looking at that affidavit refresh your memory as to whether or not you asked for the identities of donors, the bank account information of donors, and routing numbers and that sort of donors to the Give, Send, Go accounts?
Yes.
Take a look at that.
Are you going to start here?
So.
Yeah. No, okay.
Hey butterflies, how are you? I was late too. I woke up early actually, and then I turned on her courtroom and they started like a fucking half hour early. So we missed a little bit of the beginning, but not much. Yeah. Good morning.
You asked for information from Give, Send, Go. You asked for the identities of the givers, yes, the donors.
Yes,
You asked for their routing numbers for their bank accounts.
I didn't see routing numbers. Yes. Yes.
Let me point out.
You asked for
I know,
account,
right?
bank account
It's my
numbers.
fault. I wasn't.
And
Well, that's not true. I did look at her courtroom last
and
night
the
before I
amounts
went
that
to
they
bed just to
provided.
make sure. And she
Yeah.
didn't have anything like set up, which is not unusual. But yeah, it's tough with this court to tell when they're going to have their hearings. I spent a lot of time on their website the other day, and I couldn't quite make heads or
Now,
tails of
so
what the
understanding that,
courtroom schedules actually were.
can you
So
explain?
I don't know. It was a little tougher than some other websites, but I'm sure it's
It is.
somewhere.
Why would you
Here we
want to
are.
know the bank account information
Yay.
of people that are donating to my client?
Because I'm trying to determine if that, again, is owned by your client. So is that money going into your client's bank account?
No, why would you? I'm talking about the donors, not the gifts.
Because
Not where the
if
gifts
she's
and go
money
money is
laundering, or if the
leaving
Trump
gifts and
campaign
going
is giving
somewhere.
her money, if somebody
If
with
my
a
client
vested
has an
interest
account
in
with
the
gifts
outcome
and
of
go,
this,
why would you want to know the names, the routing numbers, the bank account numbers,
I'm like,
and the
stop.
amounts that
There's a
donors
reason.
have given
Just
her?
say it, investigator guy.
Like I said, to show where the money's coming from, how it's, where it's coming from and going into that account.
As always, thank you
I'm
for
trying to get
coming. My
clarification.
goodness, I'm so grateful.
You-
Really.
Want to know where the donor's money is coming from?
No.
What money? I'm
I'm trying to establish ownership of the account. And to
Okay.
establish ownership, I'm looking for names, dates of birth, email addresses, accounts of your client to show that she owns the account, that money's going into her account.
Right.
That's what's causing me confusion. How is getting the donors going to provide you that information versus asking Gifts and Go for the owner information?
So the donors, I'm not concerned about. I'm concerned about the path, the money coming in. So that,
Just
am I
say it.
concerned about it?
Is she
In terms
laundering
of
money?
how do I
Is the
describe
Trump
this?
campaign giving it? I mean, I
So,
think that's what he's trying to say, but I'm like, why aren't you just
I'm trying to
saying that?
articulate it in a manner that shows a pathway, so that just like that metadata that we talked about with social media, that shows dates, timestamps, the transfer of information. I'm looking for the same thing with this type of account. So that's why I'm concerned about the donor of the account, or the donor, and where that money's going into her account.
And you can understand I don't know that really answers the question, because you're asking for the bank account information of somebody that's not a defendant, right?
No, I'm asking for the bank account information for the defendant.
That's not what it said in your search warrant, did it?
That's what I interpreted as.
When you ask for the names of givers, bank account information of givers,
It
and
says
routing numbers of givers.
It says just bank account information. It's not. I'm not focusing on the givers. Again, I'm focusing on.
This is really
your client.
painful.
Wait, you asked for the routing numbers of the givers though?
I'm asking for all routing and bank
Oh my
account.
God.
Yes or no? Did you ask for the routing numbers of the donors?
Yes. No, I'm asking for the donor.
This is
I
terrible.
have to see the search warrant at this point because
Yeah,
I can't get a straight
I'm
answer.
kind
This
of
is terrible.
by the
I'm
question.
confused too.
Judge, if we
I'm
could
not-
print it.
I'm not
Unfortunately, I didn't
confused.
print it.
Okay.
Could I
It's about an hour.
explain
We
it?
should take a break anyways. I don't know if you want to make,
Okay.
email it to Mr. Dees and he can get it
Oh,
printed
that's
for
good.
you all. Off the record. Everyone
That's
can
good.
get 10-minute bathroom break.
There you go. Okay, 10-minute break. All right. What a nightmare. What a nightmare. Who's on first? I don't know. Third base. Who's on first? What's on second? I don't know who's on third. What the hell? This should not be that difficult. I mean, I understand it can be, but because I don't know. The guy actually is sounding like he doesn't know what he actually asked for. But I can imagine a world where for a give, send, go for a defendant, you would look at the source of the donations to check for at least money laundering, right? And then go into that further. Or someone with a vested interest in the outcome of the case, aka Trump or whatever, or the GOP, or I don't know, whoever. I could see that. I mean, why not just say that? Is that not okay? Is that against the law? I'm actually asking honestly. I don't know if maybe that information is against the law. So that could make sense. I guess I could understand that. But it doesn't really make sense to me that they're so confused by this. one question. This is a terrible amount of time to spend on this one question, I think. I mean, I understand vigorous defense, so I'll allow, not allow, but I'll allow myself to just say, "Oh, okay, that makes sense." Cuz vigorous defense should trump all of that. And I would want it, obviously. Anyone would want a vigorous defense. But at the same time, I don't know what would be the law against ensuring that the source funds weren't also corrupt or complicit in the conspiracy. You know what I mean? Like that to me would be evidence of conspiracy, or maybe, I don't know, maybe not. Maybe not. Maybe that's circumstantial kind of thing, like, well, but maybe Trump just felt like he really liked Michelle. So he's like, I want to make a donation to her legal fund because I personally like her. She gave me half of her bologna sandwich when I was coming through Michigan to a rally, and I was very hungry. And as I was walking down the red carpet from Trump Force poop, I said I started to look peckish, and I think I might have almost fainted. But then I felt this presence on my arm, almost like Jesus walking beside me. But instead it was Michelle Lundgren, and in her hand, the hand that wasn't holding me up. In her hand was half a bologna sandwich, because she had already eaten the other half. So, in her skirt. No, her skirt was short. Yes, of course her skirt was short. Of course it was. I would have my Trump ladies no other way. So, as Michelle's quite old, she's like 83, but nonetheless, that's fine. With a pair of tights, everything comes together. So as she grabbed me with one arm, I noticed in her other hand she held the other half of the bologna sandwich that she had been eating while waiting for me to arrive on Trump Force poop. So I could tell that she was searching my face for signs of life, and in an instant, as my mouth started to gape open as I was about to fall into a deep faint, right there on the tarmac, Michelle Lundgren, she stuffed that half a bologna sandwich into my mouth and moved my jaws up and down, just like yep, that's what we're doing. Just like a whatchamacallit? Wait, what? Just like a marionette. Yes, she moved my head like I was a marionette. And I chomped down on half the sandwich and sprung back to life. It was magic bologna. I'm feeling the break. How about lady following him around with a wireless printer? And I turned to the lady with the wireless printer. And I said, wireless printer lady, who also wears short skirts. Although that was a golf course. So that's just the costume. But yes, lady with the wireless printer. Make sure you print a copy of Michelle Lundgren and how heroically she saved the president's life by shoving a bologna by shoving half a bologna sandwich in my big gaping pie hole. And then marionetting me so that I had to, whatever. Anyway, sorry. Stream of consciousness. That's what we do. That's all we do. That's what we do here at Lolo's God, I hope my sound holds today. We'll see. Maybe. Maybe not. Yeah, so here we are. They started a half an hour early. Thank you very much. I wake up, I rub the little sleepies out of my eyes, wash my face, start my coffee, thinking, oh, I've got a half hour until the showtime. So cool. And then what starts happening? I start to hear noise coming from my little computer. And it happens to be Judge Simmons and her courtroom starting to bustle. And I'm like, wait a minute. And I look at the clock and I'm like, hey, wait a minute. It's 6 o'clock. You distinctly said, ma'am, 6:30. Well, 8:30. So what is it? What is this game you're playing? Anyway, so I like magic bologna. Yeah. I bet he eats a lot of magic bologna, frankly. I think that might have been one of the issues. I used to love a good bologna sandwich when I was a kid. Didn't you? I mean, did anyone? Did you like bologna and cheese? Did you ever have like bologna and American cheese on like Wonder Bread kind of thing? I don't know what it would have been called in other parts of the country. I grew up in California and we called it Wonder Bread. I don't know if it was called something else. You know, like Hellman's on the East Coast is Best Foods mayonnaise on the West Coast. That blew my mind when I was a kid. I was like, what? Wait, what? It's the same package, same product, but just a different name with mustard? All right, you're spicy. I like it. I love mustard. I'm a real mustard fan. I like mustard. I love mustard base. Bologna with mustard? Wow. Okay, well, mayonnaise would have been kind of like I don't know. I could see yeah. Oh, I have no issue with people disliking bologna. I think, it is definitely one of those things. I haven't eaten it in probably a long time. You know what else my mom made us, for some reason, we all like these now. I don't know why. Liverwurst sandwiches. Somehow my mom sold that bridge to us. I can't believe it. I can't believe she sold that to 6 kids. Like, that is just insane to me. Who could do that? That woman was magical. She was like the Mother Teresa of deli meats. God, that was wily. It was just wily. Wily of her to get us to eat liverwurst. Man. Yeah? Oh, yeah, my dad liked it too. No, I love a good liverwurst sandwich once in a while. Again, I haven't had that in probably, I don't know, 10 years, maybe. Almost palatable. Ooh, onion. Ooh, that's spicy. Onions are too spicy for me. And I actually don't really like the consistency of raw onion, but I understand. I don't know, I like liverwurst. And then I think of like White Christmas, they have that song. When you're alone, you can't sleep, you count your blessings instead of sheep. And then you fall asleep, counting your blessings. He sings that to Rosemary Clooney when they're sitting in the lodge at night having sandwiches and buttermilk. So it's like one of those childhood memories of watching that movie with my family all the time, and that scene. And then we're like, we like butterwurst too. All right. Anyway, wow. What a wayback machine this morning. I'm dreaming of a bologna sandwich with every slice of bread I eat. Yeah, crunch mitigates the worst texture. The worst. Isn't worst the worst? Worst the worst. Isn't it? I'm dreaming. Yeah. When you're do and you can't sleep, just count your blessings instead of sheep, and you'll fall asleep counting your blessings. Yeah. Ha ha ha! I'm dreaming of a white bread bologna sandwich with extra mustard on the side. Yellow mustard or Dijon or what kind of mustard? The world of mustard is like endless. We hit the hard-hitting topics here on Lolo's Lounge. Don't get it twisted. We're talking mustards, people. We're talking condiments right now. First we were talking deli meats, then we were talking parenting skills, and now we're on to condiments. Keep up. It's fast and furious here at Lolo's Lounge. Where the day yellow and spicy. Oh, I do love yellow mustard. I don't know. I'm sure that's, child of the 70s kind of thing. Eating yellow mustard. None of that but mayo, honey, adulterated mustard. Oh, interesting. That's interesting. I can't eat honey anymore. I literally get violently ill if I had a smoothie before I knew I was allergic to honey. I had a smoothie and they put honey in it or whatever. And I was immediately violently ill. And it happened again when I had some tea with some honey in it. And then I was like, oh, so this is honey. This is the problem. Because I don't eat honey that often. I don't know if agave would do the same thing to me, though. I was kind of curious to try that. Has no place in mustard. Well, okay. All right. I like Dijon mustard. That's kind of my favorite mustard. I don't like the grainy mustard. I'm not a big fan of the grainy mustard. I can appreciate the grainy mustard. Totally. From a culinary aspect, I appreciate the grainy mustard. Please, I'm not a hater. I just, taste-wise, I prefer Dijon. Even on a hot dog, I'll eat Dijon mustard and ketchup. And pickles. I don't like relish. I'm not a big relish fan. I have a friend who eats pineapple and mayo sandwiches. Oh my God. I think I knew someone who used to do that. I think someone in an old boyfriend's family who was from the Midwest, from Minnesota. I think they used to do that. I can't remember now. So I think I've heard of that. Yeah. Oh, I see what you're saying. Honey mustard. Yeah. I'm a little slow this morning. Yeah, interesting. I don't know. Curiouser and curiouser. You know what I've been eating a lot of lately? Which is probably bad. Well, maybe just once a week. No. Maybe twice a week. God, there's a place here in Los Angeles called Go-Go's Tacos. And they have the best shrimp tacos on the fucking planet. And I feel like I've eaten a lot of shrimp tacos in my life. Which I think shrimp tacos are actually my favorite food. Not pizza, not ribeye, not, spaghetti. I think shrimp tacos are my food of choice. Pretty sure. But specifically Go-Go's Tacos. And I'm not sponsored by them. I would only want to be sponsored by them in shrimp tacos. So I'm not going to turn that down. But their tacos are, if you ever have a chance to have Go-Go's Tacos, please do it because they are really good. God. Oh, these tacos are just so good. God, I could eat them right now. If you put 2 shrimp Go-Go's tacos in front of me right now, I would eat them soft. Oh yeah, soft. Soft corn. Holy crap. The way they cook the shrimp, I don't know what they put in it. I don't know how they spice it. Oh my God. It's so good. I really, bravo. Bravo, Go-Go's Tacos of Los Angeles. You have a fan. You have a lifelong fan in me. Yeah, so I've been that's an indulgence that I've had recently. Uh-oh, are we starting? Here we go. Here we go. Hey, here we go. All right. Thank you for coming to my culinary corner here at Lolo's
Michelle.
Lounge. Thank you.
Thanks. Michelle.
Michelle.
Maybe there she goes. Okay. Okay, back on the record. You can continue, counsel.
Thank you, Your Honor. Hey, Michelle, I'm going to hand you what's been marked as defendant's proposed exhibit M. And during the break, you had the chance to review your search warrant and affidavit to give send up go account.
Yes.
Right? Okay. And the record should reflect that I attended this to the Attorney General as well. So take a look at that. That is what we're talking about, right? The first 3 pages would be the search warrant itself. There's a tabulation and return, and then there is your affidavit.
Yes.
Okay. And that was signed, so we get our timing down here. That was signed by Judge Ward on August 29th? Yeah, of 2023, right?
Yes.
The defendants in this case had all been charged already, right?
Yeah.
Okay. And I want you to turn to then, I believe it's the 3rd page at the top. There's a subparagraph F. Do you see that?
Yes.
Okay. And that's what we were looking at earlier when you were looking at the computer that Ms. Chartier had?
Yeah.
Okay. And you agree with me that subparagraph asks for information from Give, Send, Go related to Amy Fashionell?
Yes.
Right? Okay. And that subparagraph asks for the givers, meaning people that donate money, right?
Contributions?
No, givers.
Givers, yes.
Okay. Contributions, meaning how much?
This is
money.
one of the
Yeah, right.
investigators,
Okay.
Gal, and
then
they're
asks
grilling
for
him
all of,
about his
routing
work, his
numbers,
looking
bank account
into the
information,
givers
tax ID
who
numbers,
gave to the Give, Send, Go for Michelle Lundgren and others.
for
So
those
he's
individuals.
trying to poke holes, I think, in the investigation
No.
into the Give, Send, Go
It
donors,
says
but
there that it
they're both
looks for
talking
that
over each
information
other.
as it
So
relates to the
it's a
people listed
mess
above,
right now.
No, for the subscribers page.
Subscribers page for those listed above.
Yes.
Okay.
Yes.
And donors and contributions are above that statement in your affidavit, right?
Yes.
Okay. But you did ask for specifically then well, you can understand someone reading that would say, you're looking for the bank account information, meaning routing numbers, bank account numbers, tax ID numbers, not the defendants, but the people giving money to the account. You can read it that way, right?
If the people at Give, Send, Go, their legal compliance were to read it that way, then they could contact me for further clarification.
Okay. So you could understand that this was a search warrant that you executed after the individuals in this case had
No,
been charged.
I don't
right?
think so.
Yeah.
Michelle Lundgren's the
And
old lady. Does that make any sense?
the account
That's
that you
the
were
best
looking
way I
for
have
from
to
Give, Send,
describe
Go were
her.
entitled
She's
legal
on
defense
Zoom
fund,
right now, but they're not showing her.
Yes.
Okay. And you
She gets
could
to call in from
understand
her
that when
house,
someone who is giving
I
money
think.
to a give, send, go account for one of these individuals that are charged here, when they find out that the Attorney General is asking for information about their routing numbers, bank account information, and their tax ID numbers, that would have a chilling effect on their desire, wouldn't you?
Objection, Your Honor. Mischaracterizes the testimony, relevance, speculation. Did you want to respond to those objections?
So I'm asking for his opinion in regard to, well, let me ask it a different way.
Okay.
I'll withdraw that
What's
question.
Patrick Burns? The girl, who's the girl that Stephanie Lambert? Isn't that her?
Before you
Isn't
prepare
that
that affidavit,
his contact? I think.
Was that affidavit reviewed by anyone at the Attorney General's?
Yeah.
Okay. And getting the names and amounts contributed of those people that are donating to the legal defense funds, was that something you put in or the AG put in?
No, I would have put it in.
Can you tell the court why it is that you would want to know the names of anybody giving money so that these people could have?
We're back. We're back to the same question he started with. He's going to give the same answer.
You asked for the givers. That's clear, right? No misunderstanding there, right?
Yeah.
And the amount given, contributions.
Yes.
And so my question was, why would that be relevant to your investigation?
To show ownership of the account.
How does knowing who gave money to an account show ownership of the account?
Kill him right
Using
now.
It's an investigation tool that we use
It's
to
not.
establish ownership. As I've mentioned before,
Listen.
there's transactions that come in and go to a specific account,
Yep.
i.e. the subscriber's page.
Yep.
They're linked. I'm sorry, the link to subscriber's page.
Yes.
So that's what I'm doing.
Oh my God. No, it's not.
That account.
Oh my God.
So the name of somebody who gives
You're
money
trying
to a
to
defendant
determine
here, pay for their lawyers,
if
is
people
shows
with vested
ownership of the account
interest
to you.
in the outcome of the
I didn't say
trial are
Why is it important to know the
donating
names
or
of the
there's
individuals
money
donating
laundering.
money?
I mean, it is part of a complete
It's important to
investigation
know
to look at all
the
of the
route,
financial
the money
aspects of the
coming
crime.
and going. It's coming
Yeah.
from one place
Exactly.
to the next to show ownership to that account.
Am I missing
that the money's
something?
going to.
Oh my God.
All right, that's your answer.
Yes.
Your Honor, I believe I would ask the court, because the court had questions, I would ask the court to admit defendant's proposed exhibit M as defendant's M.
Any objection?
And it's not offered for the proof. The matter asserted therein was just to impeach this witness.
I don't have an objection.
Defendant's M is admitted. I think you did provide him with a defense L. but-
He's got the only copy, Judge. So
Okay, well, I mean L though, as in Larry.
I did not move for admission.
I was gonna say you never moved for that. Okay.
You like it, Your Honor?
Yes, thank you.
Okay, see, the thing is, Gal, is she, and I appreciate this judge. I love this judge. She's letting as much in as possible because it's up to her to make the decision. So actually, it makes a ton of sense that she would let in as much as possible
Mr. Silvercorn
within boundaries,
and ask you questions about
knowing that she's the one that's going to have to evaluate it. So
unindicted
I don't
criminal
begrudge her any of that, but it is so frustrating to not hear people who have the
You would
ability to
review
just
the
bottom
email chain
fucking
that I
line
gave
what
you.
they're
That
trying to
was in
say. It's
defendant's
just killing. It's
L.
killing me. It's killing me.
Proposed exhibit L.
Yes.
with
It's
Kenneth
death by
Chesbrough
1,000
giving
cuts
advice as to
here
how
in
the
Michigan.
People's Exhibit number 14 should be sent off to the archive and to the Senate. Those entities. Remember that?
Yes.
Okay. And someone who assists in the commission of the crime, whether by word or deed, is a aider and abetter and is as guilty as the people that do it, correct?
Yes.
Okay. You would consider Kenneth Chesbrough then an unindicted in this case, unindicted co-conspirator in this case, correct?
Yes.
Nothing.
Mary Ann Henry has no question.
Yeah, we got to go through 8 attorneys, I think, right? Or maybe is there just 2? Oh, nope, there's 8.
Any questions?
Yeah.
No. Oh,
With the court permission to have.
okay. Prosecutor, that's fine. Sorry. Phew.
Try and do this in reverse if I can. We'll see. Investigator shock as it relates to defense exhibit M. Looking at, I believe it was third page. Paragraph, well, subparagraph F. Do you recall testifying about that?
Yes.
Now, when you're referring to the subscribers page of those listed, would that be the person's, the donors, or the person's named in paragraph B?
The person's named in paragraph B.
And those would be the listed defendants for the false slate of electors, is that correct?
Yes.
And so ultimately, the purpose of defense exhibit M, what information are you looking for?
Subscriber information, account information, account IDs, trying to establish ownership of the account and focusing on the statements that were made on the pages and then any edits that were made to those statements.
And did I hear you correctly on cross-examination that Gibson Go did not send you donor routing numbers and donations?
That's correct.
And you did not submit a subsequent search warrant seeking that information, did you?
No.
As it relates to
Yeah, they have a few.
notes that you
Mike
take
Roman too.
during your
That came
interviews
up
during the
in the first
investigation,
day.
you
So
testified
they're
that
going to
those
throw anybody
notes
they can.
are eventually destroyed, is that correct?
Yes.
In fact, these
Now,
people
the
should not be
reports that
allowed
you
to live on their own because they're
prepare,
clearly incompetent
based
and
on
are
your
often
notes?
Yes.
easily swayed to
The
do
interviews
illegal
that you take, are
acts.
those
That to me
recorded?
sounds like
Yes.
people that might need to
And
be
are those recordings preserved or destroyed?
institutionalized.
No, those were
Just kidding.
So for every interview that you have done in this case, there is likely a corresponding audio recording as well as a written report.
yes.
I feel bad for
Your
the
affidavit for
prosecutor
probable
having to, or the
cause.
state
paragraphs
having
that,
to
were not authored
address
by you,
all of this
38 through
nonsense piece by
45.
piece by piece by piece.
What's
They can't
contained
take
in
for
those
granted that
paragraphs?
they can't
The count
leave
of the
something
charges.
unaddressed. How
And
fucking
as the
tedious.
investigator of the case, are you responsible for determining the charges?
No.
But you read those paragraphs, correct?
Yeah.
And in order for you to swear to those paragraphs, did you make sure that you were comfortable that your facts in the affidavit corresponded with those charges?
Yeah.
And did you in fact swear to the entirety of that affidavit, including paragraphs 38 and 45?
Yes.
Now, during Mr. Silverthorne's cross-examination, he discussed whether or not Ms. Lundgren only stated that she signed a signed-in sheet. Do you remember that line of questioning?
Yes.
As part of your investigation, did you review Ms. Lundgren's social media?
Yes.
permission to approach, Your Honor?
Yes.
I'm gonna hand you what has been admitted as exhibit 28. And I'm drawing your attention to the, excuse me, fifth and final page. Meta identifies it as page 5730. Okay.
Yeah.
And I'm drawing your attention to the highlighted portion. Can you read the highlighted portion, please?
Yes. This was a big Trump legal, I'm sorry, there was a big Trump legal team present. They know what needs to be done. I was proud to be in the midst of patriots. We signed all necessary docs. We took photos of all of us. We tried to enter into the building. We were obstructed, but we did everything and we are well documented. Peace, period.
Doesn't say anything about signing just a sign-in sheet, does it?
No,
No. No. Oh, Michelle.
I'm sorry.
Michelle.
So that statement's going, I don't know who made that statement.
For
You think that was supposed to be on Ms.
the
Lundgren's
biggest
Facebook or
lie
social media?
there
Yes.
was.
Thank you, Judge. I'm objecting to that statement being used.
Wait, I don't know. What rhymes with was?
Been in this case, and I don't have the.
I don't know what rhymes with was.
Maker of that statement.
Michelle,
So,
you
that statement
fell. Yeah, laying
it's
out the
going to be used as
crimes.
special
That's
knowledge.
me, Michelle, laying out the crimes
It's
on
my
the
understanding
Facebook.
redirect, I'm limited to the scope of cross, and I was directly addressing a statement that was solicited by Ms. Lundgren's attorney, Mr. Silverthorne, that she only signed the sign-in sheet.
Okay, so if it's only used against Ms. Lundgren, it's fine.
Yeah, because
Thank
she's got to address everybody at one
Sure.
time, so.
I got it. Thank you, Judge.
Thank you.
It's a lot of y'all.
Yeah, that's not funny. Okay, there's a
Kenneth
lot of
Chester.
y'all is not a. The judge isn't being
He
funny.
testified that he
She's
is
stating a
considered an
fact.
Unindicted co-conspirator in the state of Michigan. Are you aware if he is either indicted or unindicted anywhere else in the United States?
yes,
Where?
Georgia,
And what's the current state of his Georgia case?
he pled guilty. He pled guilty to filing a false document, I believe it was, in an election fraud case.
Stemming from the 2020 election, is that correct?
Yes,
Thank you.
Your Honor, I believe he pled under advisement and the case will be
Oh,
dismissed.
shut
against
up.
him at the conclusion of that period.
Kiss my fucking ass,
He
So,
still
just so
entered
the
the
record
plea.
is clear.
idiot.
He still entered the plea, correct?
yes, he did.
Thank you.
He put under advisement and,
In Georgia.
no, I know it was in Georgia and the plea would, or
The
the,
case is going to be dismissed against him, so there will be no conviction against Mr. Chesbro.
after a
Excuse
period of
me?
supervision, I'm supposing. Is that,
What?
and there was a factual basis that was entered.
It was.
Oh. Thank you.
I what?
May I proceed?
You may.
Hmm.
Now, you testified both on direct and cross that your investigation began December 2022, is that correct?
Yes,
And during your investigation, did you basically have to step back into what the conditions were in December 2020?
If I have
Yes.
to plead,
And
if I
as of
plead under
December
advisement, all of a
14th,
sudden I'm not
2020,
guilty? Is that what we're trying to say here?
The Michigan
Is
electoral
that
votes
what
were
we're
certified
saying?
for
Is
which
that if I
part?
plead guilty, but I say,
The
well, but it
Democratic
was under advisement,
Had a
that means
recount been
I didn't do
requested?
it?
no.
What the,
Had a
that's
recount,
get
that's
out
my
of
knowledge.
here.
had a recount been ordered?
No,
The certificate of ascertainment that you obtained during your investigation was for which party?
the Democratic electors,
And during your investigation, did you obtain information about statements made by Mike Shirkey and Lee Chatfield?
yes,
Mike Shirkey was Senator Georgia leader, is that correct?
yes,
And Lee Chatfield, Speaker of the
Speaker of
House?
the House, yes,
And was it related to Michigan's election results for the 2020 election.
Yes,
And did that have an effect on you as a listener?
yes, it did.
And what were those statements?
I'm going to object as to hearsay because I think, based on that question, this is not about the effect on agent shock. I think it's to try to get those in as a fact that, for example, Speaker Chatfield and Mike Shirkey indicated that they were going to be certifying the votes for, at that time, soon to be President Biden. And the other thing is, this already was covered on direct when we were here a couple of months ago. And I don't believe that there has been cross on Chatfield or Shirkey's comments. I believe that Agent Schatz brought up Shirkey yesterday, but I think that was brought up on his own. I don't think any lawyer asked about them.
Well, it doesn't matter if the specific question references it. If the answer elicits that information, I'm allowed to redirect them.
Not if he's opening up the door. If he were our witness, then that I think would be a very different story. But she's got her own agent up here opening up the door to comment. So now that the assistant AG can now ask about them.
Correct. He's not, they called him as a witness, but he's your investigator.
And actually the AG called him as a witness.
Oh,
We're
I
just
called him as a
crossing him.
witness.
We're just
Okay.
crossing him.
Okay,
Yeah, no, I called him as a witness.
gotcha. And so he's your witness.
Ah,
He was not directly asked by any of the defense counsels about anything that Shirkey said.
All right.
Objection sustained.
Well, Your Honor, I still think it's effect on the listener, but I will not go the scenic route.
Yeah, because again, you're bringing in some statements that they don't have the opportunity to cross-examine on.
Please.
But not about Shirkey.
I will move on.
Thank you. And they have to cross-examine for days because it's 6 attorneys. So it takes a while, especially if Janini and Kroger are going to cross-examine.
That is fair. Okay. Now, moving forward back to December 2022, when you are actually investigating this, between December 2020 and December 2022, had there been a recount of the Michigan election?
No,
Were the Dems still declared, the Democrats still declared the winners of the Michigan votes for 2020?
yes,
Had there been any change to the certificate of ascertainment for the 2020 election, naming the Republican slate as the electors for Michigan?
no,
Were there any successful legal challenges on their merits?
Objection, Your Honor, only because this has been asked and answered. This was
dog
covered in direct.
calls, time to
questions
walk
about
that little
Lawsuits that were still
puppy.
pending
I'll
on
be RB.
cross, but I mean, this has all been covered.
It was also asked on cross, and I'm allowed to redirect.
But redirect on the same cumulative questions that were asked on direct.
I think that's what she's saying, that these were already asked, and so she's asking why you're redirecting.
I
on it.
believe there were several questions on cross-examination about the status of legal challenges
There were.
and their pendency. And so I believe I'm allowed to redirect them.
We're not disputing that, but you're asking essentially the same questions and we're getting the same answers. I don't know if you want to pinpoint the questions or redirect issues that are unclear. Because these were issues that were unclear based on his testimony. Yes.
I raised the question about legal challenges in other states. Ms. Logan objected to it, and Your Honor ruled it was not relevant. So it doesn't exist.
Agent Schock, I believe, had said something like he was not aware of any pending judicial actions. And again, that's a paraphrase when he was asked on direct. And I believe that lawyers asked about pending legal actions at the time. I think, again, to kind of call the same direct over again. I mean, I know we joke about, Mr. Koger and Mr. Danini taking the scenic route, but now we are on a scenic route, on a route we've already driven down, right? At least their route was new. We were seeing new things. Now we're seeing the same things.
Well, Your Honor.
Mr. Janini, did you
Well, Your
decide
Honor,
not to speak?
Mine is. I was thinking about that.
To respond.
The
You
question.
are, but you want to respond after each? Is that what you want to do?
Well, I don't know.
You can respond to her, but then he's gonna say something, then you gotta respond again. It's up to you how you
I
wanna
would
do it.
rather do that.
Let's do it.
There was extensive cross-examination, specifically naming cases yesterday during cross-examination. So I believe I'm allowed to clarify the status of those cases in at the time that this investigator took over this case and whether or not how they were resolved. I'm allowed to do that.
The one thing that's significant though is what, oh, I'm sorry.
Mr. Danini had something he wanted to add.
Your Honor, my point is that the fact that these cases were ultimately resolved in favor of the Democratic slate is kind of beside the point. The point that was made is that there was a possibility that these cases could have been resolved in President Trump, former President Trump's favor between December 14, 2020 and January 6, 2021. So when the prosecution is asking questions about what happened in 2022, they can ask that all they want as far as I'm concerned, because they don't matter.
I did not ask that question.
Yeah,
I
you
didn't even get a chance to finish my question, actually.
And I believe with Mr. Danini, unless they're somehow showing that there's a conspiracy that's ongoing in 2022 and these judicial actions are decided, and I don't believe that's the case, then it's totally irrelevant. What's irrelevant is the intent when this document is signed on December 14th, 2020. And then what might be relevant for intent is what Sean Flynn is thinking when he actually mails the document, since he's an unindicted co-conspirator. But what happens 6 months later or 9 months later is totally irrelevant to what the intent was when this document was signed.
I don't even think she finished her question though.
I do, but I think we're, that is in response, that was not the question that was asked, but that was in response to why the question was being asked.
And just for, she didn't finish her list of questions, but that was exactly her question. Her question was, did it resolve, was there a recount, and did the cases resolve ultimately in the Republicans' favor? So
Right,
that's
but
exactly the question.
to her point, there was questions, I think by you mainly yesterday, in depth about the number of the cases, and I think you were going along the lines of, could that have had an effect on his investigation or his affidavit to charge? And so that's why she's redirecting as to what happened in those cases, is what I'm assuming.
I believe we went into depth about some statements that were in an affidavit. I should be allowed to redirect on those.
I'm overruling the objection.
Thank you.
Continue.
More questions? When you start your investigation in December 2022 and you're looking back to December 2020, specifically the legal challenges, were any of those legal challenges successful on their merits?
No.
Now, specifically talking about the Constantino versus the city of Detroit, which you were asked about yesterday. Do you remember that line of questioning?
I remember the case, them asking me. It was a long day. I don't remember the line of questioning.
During your investigation, which started in December 2020, were you able to substantiate any of those allegations of fraud in the city of Detroit?
No.
I'll just object on relevance. Again, my point is, whether they were ultimately successful allegations does not matter. Were the allegations pending as of December 14, 2020? Yes, they were. Could they have resulted in a ruling in the Republican side's favor? Yes. Were they ultimately successful? No, I don't dispute that. I never made an argument to suggest that the ultimate success of the litigation mattered at all.
You haven't made any argument yet.
To the extent that the court wants to hear about the ultimate determination of these cases, that's fine, but my objection is relevance because it's completely irrelevant.
Well, you brought it up as to the effect it had on his investigation. I'm assuming that's what she's addressing.
Yes.
Okay, let's see what the effect of a successful or unsuccessful case is.
I join in Mr. Danini's objection, but I also object on relevance grounds because I haven't heard anything from Agent Schock that he actually was investigating voter fraud. I've heard that it's starting in December 2022, he was investigating these 16 individuals, but I haven't heard that he was, investigating Antrim County or what was occurring in Detroit or anything like that. I don't believe we've gotten any reports on those investigations. So I think he's limited his work has been limited to the electors. I mean, that's like saying, have I uncovered voter fraud in Detroit? It's not my job.
Well,
I
he
haven't
was
heard it.
specifically questioned about that case and if that case had an effect on his investigation.
The only, I would just object to the phrasing of the question and essentially was, did you uncover voter fraud in Detroit? Because I don't think that was his job.
I did not, that was not my question. My question was he able to substantiate the allegations?
But
I didn't ask him if he uncovered voter fraud in the city of Detroit.
Well, substantiating the allegations would mean, what could be interpreted that he was the one doing the investigation.
Well, if the allegations had an impact on the listener, then I'm allowed to ask if he was able to ascertain the truthfulness or the veracity of those allegations, because that would impact his investigation and how he proceeded, whether or not he could ascertain whether or not.
I'm not disputing that, but your question was whether or not he was able to substantiate any voter fraud, and he didn't do the substantiation of voter fraud on that case. Whether or not voter fraud was substantiated on that case was not something he did.
Well, Your Honor, I'm not, okay, I'll rephrase the question because that's not what I'm trying to ask.
I realize that.
What's the matter, everybody?
Point. So
What's
to
going
the extent you'll
on?
rephrase the question, the objection.
Everybody's arguing.
To referring back to Constantino versus the city of Detroit, and specifically the allegations that you were asked about on cross-examination, as part of your investigation, did you find any support for those allegations?
No.
And how did that affect your investigation?
I took it into consideration with all the other information that was involved in my investigation.
I'm sorry, Your Honor, but just again, to the point that was made, the question I believe was, did you find any support for those allegations? Unless we can do an offer of proof, if the witness, for example, interviewed Jesse Jacob, who was the affiant in the case that I went through the affidavit of, or some of the others, and said, you said this in your affidavit, and then he decides it's not true, that's where he's deciding whether the allegations have any merit. But I'm not sure what he did in his investigation. I haven't seen
think
any.
the question was whether or not he decided that the allegations have any merit. Someone determined that those allegations didn't have any merit, correct?
Yes.
Not him.
That's my thing. I don't think that's her question, or that it's not her intent to make that the question, whether or not he made the determination. I don't think it's disputed that he didn't do any investigation as it relates to that case.
Fair enough.
I think she's saying the ultimate outcome of that case was that there was no valid allegations sustained. Is that correct?
Yes.
Okay.
And
so-
did that ultimate decision have an effect on his investigation in this case?
Fair enough. And just
Exactly.
one other point that did come out on cross-examination, most of those cases got dismissed on procedural grounds, never went to the merits. that's
Shut the
important for
fuck
this
up,
court, and it should be
counselor.
important for
Sit
this witness to
down.
understand.
I don't remember.
Pat
any question about
Oswalt,
that,
sit
though.
the fuck
did.
down. Sit down,
If they were dismissed on the
counselor.
merits versus.
That they were dismissed on procedural grounds and not.
No,
Well, I don't believe that was listed.
I do not believe that is
We have a
true.
record,
We got a
so
transcript.
we'll check it.
Now, you were asked, I believe, today about King v. Whitmer.
Yes.
And are you familiar with that case?
Yes.
And during your investigation, did you learn whether or not that case was successful on its merits?
He's so full of it.
I learned that the case was dismissed.
And how, if in any way, did it impact your investigation, sir?
I took it into consideration along with all the other cases and information that I reviewed.
Now, are you aware of when, you know what, never mind, strike that. Are you aware that King v. Whitmer went through several layers of the court system?
No, I'd have to refer to the case itself to, recall my memory.
I couldn't, his voice trailed off at the
I'm
end.
sorry, I'd have to refer to the case.
Okay. You said you couldn't remember, is that what you said?
Yes.
So is it fair to say that without looking at a document to refresh your memory, would you be able to say when King v. Whitmer was first
How are you?
in the Eastern District of Michigan?
I would have to look at the documentation for that.
I feel like I need to fill the silence.
All right. I'm not
Okay,
really sure
wait,
how I'm
no.
gonna show this to Secretary.
Wait, what? This weed is really hitting. It's hitting the right way. I'm good. I'm
think
pretty
the court
high,
can
and
take
that's pretty
judicial
good.
Notice of
Yeah.
when the
I'm feeling
first
pretty good. Okay. I'm
opinion
pretty
as it related to King
feeling
v.
pretty good.
Whitmer
Okay,
was
over
filed.
here.
It's
What I
at,
meant was I'm feeling pretty
505
okay over here,
Fed
but then I
Supplement
went
3rd 720,
pretty good.
a
Okay.
2020
Yeah,
case.
it got all
The author
kinds of
is
fucked up.
Judge
Anyway,
Brenda
hope you're
Parker
good.
of the Eastern
Hope the
District
baby's
of
good.
Michigan. And it was signed on December 2nd, 2020.
So noted.
Your Honor, I'm gonna object I'm trying to pull this up and catch up here on the
Hold
fly.
You can come over and look at it here too.
Yeah, I'm
That would be
looking at the
helpful. I
docket
mean,
sheet.
if anybody has any doubt, she has the case pulled up right
Well,
here.
she's talking about the first opinion. What does
That's
the first
exactly what she
opinion got
said.
to do with whether the case was allowed?
Whoa. Whoa. Slow your roll, asshole. There's no need to be a jerk about it. Come on now. Have some decorum. Aren't you attorneys supposed to have decorum? What happened to that? Where has all decorum gone? Long time passing. Ooh, long time ago. Yeah, I don't know the words to that song. I don't know the words to any song, really. What are we doing? What is everybody looking at?
Provided the citation to the court. The court.
Okay.
I'm giving them an opportunity to pull it up.
Yeah, Your Honor, as I'm going through, so my objection is, the question is improper. There's appears to be a December opinion, and so certainly the Attorney General's office is allowed to ask questions about that, but case goes on well into 21 and looks like even 22. I know there were sanctions issues, but the thing that she's pointing to is a preliminary injunction order. So the case obviously goes on beyond temporary, a TRO request and relief. Yeah. And it did.
Then
and
what?
There's still.
You both can't talk at the same time.
And then what happened?
Okay, I'm done.
Okay.
I was part of that litigation.
Oh,
That-
well,
and
that's
so
not a flex.
The case was voluntarily
Wait,
dismissed.
what are we
That's just
talking
not a
about here?
flex.
Wait, we're asking, so I'm just trying to
That's
clarify.
what they
the-
trying to
Dude,
establish.
you're
She's
not gonna
asking
say
us to
wait
stipulate
to
or
that
the court
judge.
takes judicial notice. We're objecting to it because it doesn't answer the question.
I can't fucking
If
stand
I
that
may.
guy. Anybody know who that guy is?
Yes.
I'm into
If I
disbarments
may,
these
I
days.
think part of the problem when
I'm
you're
into
asking about the court to take judicial notice. of, for
advancing
example, one
disbarments.
Opinion on a docket, or there was a docket, it's not complete, and I think that is potentially misleading to the court. A possible solution is, because I know we are briefing things, is, for example, if the question was there an opinion on December 14th, whatever it may be, seems probably fine, given in light of the cross yesterday. But if the court wants to take judicial notice, or a party wants the court to, of a docket, an entire docket, I think that's much more beneficial to the court to see the litigation, not just when it started, not just when the first opinion was issued on a preliminary injunction, but also how long things continued on. I think that could probably clear up all of this.
Your questions, particularly to this witness regarding what you want the court to take judicial notices is when the case ended?
No,
Or what?
when the first opinion was issued on King v. Whitmer.
The first opinion on,
King v. Whitmer.
I know, on,
I can check the relevance.
So, and look, I'm gonna join just because I think for the court, if we're gonna do this, I stipulate, at least on behalf of Ms. Burden, that we can have the docket sheet printed for King v. Whitmer, and we will hand it into the court as the next people's exhibit or defense exhibit, and the court can certainly read a docket sheet.
I believe I am allowed to redirect when this is brought up in cross and.
I don't think they're disputing you redirecting. They're talking about me taking judicial notice with the citation you're providing. They would, that's what they're objecting to.
This is an opinion that was issued this day, nothing more.
Yes.
Yeah, but it's not just that it was an opinion. I think the objection is that was the first opinion. Is that the objection?
My objection is relevant. So why is it relevant? It's an opinion in a case. It still pens after that date. So we're talking about the termination date. Is being
I don't know if that was just her laying the foundation for a question.
It was.
So I don't know what the relevance is yet. But before we get to the question, there was an issue as to the timeline of this first opinion. And so she, because he couldn't recall, was going to have me take judicial notice of when that opinion was, but there's an objection. So I think I like the idea of just the stipulation to the docket sheet. I can read a federal docket sheet that resolves it. And I can determine whether or not the date of the first opinion based on that docket sheet. Now you can ask your question.
Okay. If I can have a moment.
Take your time.
I just think it's really hard I would imagine it's really hard for prosecutors and others who haven't been like following election, fuckery, almost like a soap opera, like I do. And then not having that context of who's really like, I don't know. I mean, I understand investigators, everybody's doing such a professional job that the information that comes through is probably really good and really gets them up to speed. And they're probably aware, obviously, of what's in the ether. I'm not saying that. But I'm just saying that they wouldn't pay necessarily as close attention to the ins and outs and the who's who and the Mike Romans and the this and that.
Yeah.
Obviously, they come to light. But I just find it really fascinating.
It's part of your investigation.
That people can jump that far
Looking
into
back
this
specifically
quagmire
referring
so
to
quickly.
King v. Whitmer.
So I
Did
think
you
it's a
take
lot.
into consideration the opinion that was authored on December 7th, 2020.
Yes.
And based on your investigation, did that ultimately culminate in you drafting your affidavit for probable cause?
Yeah.
I'm sorry, did that ultimately culminate? Did the reading of a specific case culminate?
Based on his investigation.
Well, I thought your question was him reading of this opinion from December 27, 2020.
I said, did he take that into consideration? And then I had moved on to another topic.
Okay.
Oh, okay. And then I would draw.
Now, based on your entire investigation, the information that you gathered, did that ultimately help you author your affidavit for probable cause?
Yeah.
The information that you received from Kenneth Chesbrough, did you receive that information before July of 2023?
No,
When did you receive that information?
shortly before December 6th, 2023.
Did you review the information that you received from Mr. Chesbrough?
Yes.
Did the information that you received from Chesbrough either support your findings in your investigation or lead you to believe that your findings might be incorrect?
Supported my findings.
And lastly, Permission to approach, Your Honor?
Yes.
But if hand you people, Defendants B and People's Exhibit 14. And first, I'm going to ask you about Defendants B. And just could you remind us what that is, sir?
Yes, this is a document, says State of Michigan Declaration to the Senate and House of Representatives. It's a recognition of presidential electors designated for Donald J. Trump and Michael R. Pence, signed by Kathy Burden. On
Wait, did he just say
December
chump?
14th, 2020.
Did he literally say
notarized
chump?
By Henrietta Toll.
Oh my God.
During your investigation, did you come into possession of a signed copy of that document, Defense B?
No,
When did you come into possession of a copy of Defense B?
during the attorney proper with Mr. Janini and Mr. Koger.
Could you remind us again what People's Exhibit 14 is?
That's the, the memorandum and the certificate of votes for the 2020 electors from Michigan, Republican electors.
Now, going back to Defense B, during your investigation, were you able to determine who was involved in the creation of that document?
Yes,
And who were those people?
Laura Cox and Stuart Sanders.
And does Defense B contain alternate language?
Yes,
How
So
many
what does
sig-
alternate language mean?
Can you clarify what alternate language means?
What's alternate language, man?
contingent language.
Thank you. How many signature lines, not counting the notary, are on Defense Exhibit B?
One,
Now, going back to People's Exhibit 14. Does that document contain contingent language?
no,
How many signature lines does that document contain?
we have 16,
Oh, sorry, just the signature page. I'm
just the
sorry.
signature, okay, 16.
And are there any signatures missing on the signature page?
No,
I believe there are additional documents in line with the signature page. What are those again, sir?
this is the alternates that were selected to fill a vacancy.
And each of those pages bear how many signature lines?
Two,
Any signatures? Any signatures missing on any of those pages?
no,
And that's the document that does not contain contingent language, correct?
correct.
And during your investigation, which of those documents was sent to the National Archives and to the President of the Senate?
It's the People's Exhibit 14.
Thank you. Nothing further.
May this witness be excused?
Yes, please.
May be excused. Okay, and so there was gonna be a new witness call, but it's about 11:09. Who's our next witness?
The people have no further witnesses, Your Honor.
Your Honor, may we have a brief recess to?
We're going to have, we're gonna have lunch. I just want to know who the witness is. Are you gonna determine if you need to call a witness?
Yes.
Okay,
That's-
sounds good.
We just take
We have even, not even 5 minutes.
Oh, okay. You can take 10 minutes in case anyone has to go to the restroom because they would have to go all the way downstairs.
So just so I'm clear, the state has rested and now.
The state of rested.
Understood. Okay, thank you, Your Honor.
Woo! The state has rested. It's time. The state's gonna go take a nap. Yeah. Wow. Wow. That was a quick case. Because I feel like I didn't even see her case. I guess this is just the preliminary hearing, though, to determine if they go to trial. So this is definitely, a specific purpose and limited probably in scope to what is carry forwardable to be very specific about it. Yeah, so that okay, well that's interesting. I don't know. You know, the problem with this case for me is that I mean, I know the basics of the case, but I don't quite, I mean, and I think I'm getting a vision of what the common defense is, which is, I didn't know what money was. I'm just a baby, you know, that kind of thing. So it was like, oh, well, I don't know. I was just signing a sign-in sheet, and then all of a sudden there was coffee cake, you know, like that kind of thing. And I'm like, well, then why are you an elector? Because if you're not smart enough to figure out what kind of room you're in and what's happening, even after being refused entry to the Capitol, then, you know, I don't know what to tell you. Then I don't think you can actually take care of yourself. I don't think you actually should be in charge of your own finances. So, I don't know. Your family needs to maybe do a wellness check. That just seems like the most ridiculous, stupid statement in the world to me. Let's see. What time is it, though? Okay. So it's, wait, what? So it's 11? Is it 11:15 there? Is Michigan in the East Coast? Is Michigan East Coast? Is my mind about to be blown that I thought it was all this time in the Central Time Zone and now it's in the East Coast? Or maybe, like, have I gone back at times? I don't even know what's happening right now. I know for a fact they started a half hour early, and I'm gonna let go of it by the end of this broadcast, but not yet. Anyway, good morning. Good morning. Good morning. It's great to stay up late. Good morning. Good morning to you. Yeah. So, well, it's cold this morning here in Los Angeles. It's sunny though. It's really a beautiful morning, actually. It's really quite beautiful. But it's a cold one. So I have a sweater on because I'm cold. Let's see. So I actually didn't really expect them to take lunch so soon. So I'm a little high. I'm not using that as an excuse. I'm just giving context. And trying to think. Yeah, I'm trying to kind of motivate myself to go look at Twitter or something so I can share whatever is like. I don't know what's happening Is David Pecker still on the stand? Are they? Oh no, today's Wednesday, right? Today's their down day. Well, not down day. Today's like office day. You know, like study hall. So yeah, so there's no news coming out of that courtroom in New York where Chump is. That's a great one. Why didn't I never used that. Why in the world did I never call him Chump all these fucking years? That's so dumb. I called him Dump, but never Chump. God, that was a gross oversight. That's right. Court is out today. Yeah, I think it's study hall. It's judge study hall. They get to do their thing. Oh wait, this is only a 10-minute break. I'm so confused. Ugh. You know, this is one of those mornings when I should just be like, be still and listen. And my eyes a little. I feel like there's a lot of pollen in the air. But only one eye is puffier than the other. I don't understand why one eye could be puffier than the other. I'll try and do this without ruining the sound. I can't tell what ruins the sound with this thing. I feel like while it's not delicate, it's incredibly delicate. And that shouldn't be, right? Because it's just a microphone cord. I mean, what about Janis Joplin? What if she was like throwing this microphone all around? You're telling me it would cut out in the middle? Take another piece of my... I mean, how terrible would that be? They don't make microphones like they used to. Ow. God. I think all my stuff is tangled. Oh, what a tangled web we weave when we sleep like a maniac. Yeah, I got a lot of like, I still have, like, I'm in the midst of organizing the room that I'm in right now. And it's just taking so long. I don't have remember that silly little dressing booth I got? I still haven't built that. It's sitting in the box right here, right next to me. And as soon as I clear a spot, which is literally all I have to do, then I can build it. And then I can scream my little heart out. Scream. Scream, scream, scream. Scream. Scream, 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 scream. No, I'm going to try not to. But I really would, it would be really fun to do that and get that taken care of. I would enjoy that very much. Hey, where's my other necklace? Oh, it's right there. Everything is all tangled up. I'm hungry. Oh my God. Wait, what now? A brunch hot dog. Oh my God. I know, right, Teresa? Now I'm like, I'd take a bologna sandwich right now. I'm going to be honest with you. Oh God. You know what? Yeah, I was supposed to do something. I forgot. Hold on. It looks like we're all coming back into the courtroom. Who's that one lawyer that's all pissy? The guy that had his back to us down at the bottom of the screen that was all like, meh, 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 meh. Well, well, well. I'm like, well, what? Well, what? No, I'm just kidding. I understand vigorous defense. Blah, blah, blah. No, I'm just kidding. I'm just kidding. Oh, God. I keep thinking about tacos. I'm sorry. I have to put on my glasses. I'm going to go ahead and turn their sound on in case they decide they need to. Bow, 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 bow. All right. Boop, 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 boop. Boop, boop, boop. Boop, boop, boop. Boop, boop, boop. What the heck? I don't get that. Oh, I see. Oh, I see. Wait, what is that? The bald one? No, he wasn't bald. I think he had some hair. But you know what? My vision isn't that good. So right now, it might be that he didn't. I should leave my glasses on, then I could probably see what he looked like. I don't think he's in frame right now. He's not that guy standing right there. And it looked like it was kind of salt and pepper hair, not. Now I just don't know. Do 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 do. Oh, you know what that's. Do do do. I got the fake elector blues. I was only signing a sign-in sheet. I didn't mean going to do it. Someone told me we were just about to have. I swear to God, if you knock something over, Samwise, nothing will happen. But please don't. I got the fake Elector blues. I thought it was who was gonna bring the dessert. Here's the thing. Oh. Yes. I know. I blew it. Yeah. No. You didn't blow it. Well, yeah. I understand that. Okay, I'm looking at this place, Acai, por favor. Yeah. All right, I'm gonna start a cart. Start a cart. Start a cart. Start a cart. I think the dog has an upset tummy because he seems to be a little on edge today. Oh no, a little nervous. A little anxious to go places. To go places. I have to show you this picture though of what I turned around to when I. Oh no. I stood up. There's two pictures. Oh my God. Okay, I'm looking. Oh my God. He's so cute. Oh, look at the little nose. He's cute. We have such a cute little old dog. I think he's about, no, he's probably 13 this year. I keep getting it wrong, but literally I'm convinced it was 2011. So maybe, I don't know, because it was early in 2011, right? So he could have been born earlier, I guess. I don't know. Yeah. Yeah. So who's to say? He's 13 or 14. Yeah, exactly. I think he's 13 because he was pretty little when we got him. Yeah, that's true. Come here, baby. No, Papa. Anyway, did you? Yeah, no, I didn't. Stop interrupting me. This is all your fault. Yeah, it's my fault. It is your fault. Totally, 100%. I gotta say, I'm thinking of the place we had. Yeah. Is that bad? No, I don't know what the cost was. So. Well. I don't know if I want to know. Was it great? But it was so good. Listen, I say live a little. No. Was one place too that I really liked, and I can't remember how expensive it was. Oh, it was Juice Crafters. No, it wasn't actually. Well, it was kind of. Backyard Bowls. That's the place that I really like. Oh, is it? Yeah. Okay. Well, let's do that one. Well, let me see how expensive those are. Well, don't worry. I mean, it's not more expensive than the one we ordered the other day. I don't know. Why are acai bowls so fucking expensive? I know, right? What is it magic fruit? I mean, it is magic fruit. I shouldn't say that. Now the magic fruit gods are gonna pass over me. But it must be expensive. I mean, the ingredients are expensive, so maybe that. You know what? I'm sorry. I take it all back. I understand. I understand exactly why they're so expensive because somebody has to put them together by hand and that takes time. So I will, and you know what the thing is I know for me that I could. Be any more expensive than like ice cream or frozen yogurt. Well, but the bowls are like made. I'm going to disagree with you on this one. That's like a handcrafted thing. All right. Well, yeah. Are you going to do it? I just added one. Okay, great. Yeah, I think. Okay, fabulous. Oh, that's not actually more, by the way. It's not? No. Oh, wow. No, that's actually less. This is a good place. This is what I used to get all the time at Really? Yeah, at work. Really? Yeah. Wow. The only time that they poisoned me was when I got I got a bowl that And they said no.
They've done that before, just fine.
Right.
But they did it that one time
Yeah.
incorrectly.
Oopsie.
But it's okay.
Okay. Well, you're still here.
Yeah.
No blood, no foul.
Oh my God.
Oh, this is the place.
Your yarn. Can you please look over here for a second?
What?
Look at the yarn and where Gus is.
What?
He just smacked the shit out of it. He just smacked. He was like, "What the fuck is your problem?" He does not understand it. Come here, baby. Come here.
Okay. All right. God, sometimes I really want like a peanut butter part of acai, right? But then I'm afraid.
Well, why, pussy?
What are you still doing here? Why are you still here? Never mind.
Okay, I'm leaving.
Okay. I love you very much. I do. I need it not. Oh, here we go. No honey. Yeah, because I'm allergic to honey, and that'll be. My wife made a Chinese hot dog pizza as a joke for a friend. I bet you that was good. There's nothing wrong with those combinations. But the fake Elector blues, yeah, butterflies. These people are gonna have the blues, God willing. I'll tell you that. Right now. But you are, Blanche, you are. Gosh, do I want to try that? No, I don't think I want to try that. Oops. Oh, I see. I understand. I'm afraid I'm going to try this. Do. Wow. All right, sweet. Done and done. I got the fake Elector blues. I wanted my name in the news. That Trump, he's no chump. He would never dump me as a fake Elector. I'm putting it all out there for that guy. Please don't pass me by. Pardon me. I got the fake Elector blues. I didn't want my name in the news. I got a case I'm about to lose.
Yeah, Mr. Coder.
Like he's right there.
Oh,
That's for you,
Okay,
butterflies.
back on the record, and is the defense going to be calling any witnesses?
Your Honor, I think I have what hopefully the court will perceive to be good news. We believe we presented our evidence through the people's case. We believe we elicited testimony through cross-examination of witnesses that supports our position that the court should not bind over and these defendants. And so the defense will not be presenting the defense case.
Okay. That's consistent with every other defense.
That's, well, I'm sorry, Your Honor. That's correct as to Mr. Haggard. We are not presenting any witnesses.
Michelle and Matt will not be presenting any witnesses.
Mary Ann Henry is not calling any witnesses.
On behalf of Ms. Pessin, I'll object to the arrest.
On behalf of Michelle Lundgren, we also rest.
Okay, so with that being stated, we previously indicated that there will be bind over argument made by way of briefs and not on the record. and so that you can submit your writings. I'll give you a schedule for that. Council?
Well, in regard to that, Judge, we need transcripts, I think.
That's fine, because I'm not gonna give my ruling until I finish the second batch anyways.
Okay.
So, you'll have time to do that.
That was gonna be my question. So is the court gonna keep?
So this must be 4
briefing
of the last
schedule
8.
After the receipt of the transcripts, or just pick dates now?
Well, we have to see how long it's gonna take, or estimation, I should say, for the transcript. I believe that's being farmed out, correct?
Your Honor, if we're going to be waiting until after all of the other defenses have gone, I'd like an opportunity to see those transcripts as well.
I'm not gonna give you an opportunity to see those transcripts, just like they're not issuing bind over based on yours. You're issuing your bind over based on your presentation and who you cross-examine. And then I will handle those, and then everybody will get their bind over argument at the same time. I mean, their bind over ruling at the same time, not argument. So no, I'm not gonna hold this over until 2025 so that we can get everybody's transcripts, and hopefully it won't take that long to proceed with the others. We're scheduled to proceed with the next batch, I believe the end of May. Yeah, May 28th, 29th, 30th, 31st, June 3rd, 4th, and 5th. So I set a time 7 days consecutively so that we can run through this. Understanding that it's going to be more attorneys, so that means more cross-examinations and more objections and more motions. So it may take.
I won't be there, Your Honor.
And that right there probably encompasses 3 attorneys. And so that, hopefully that 7 days should suffice to get that squared away. And so what I'll do is we will find out an estimation of when we can expect to have the transcripts completed. And from that, you'll get notice from my assistant as to when you should have your bind over arguments for or against bind over, that is, into the court. Because I want to give you reasonable time to review those transcripts as well, okay? Thank you.
Will there be an increase in the page limit? So I know right now it's 20, but there's a lot with 8 counts and all these days. Exciting law, in fact, so I would request possibly 30 pages.
I was gonna ask.
We already knew you were gonna ask.
I
That was what was going on in my head. Why would you encourage this?
Hey, send in the Marines, right? So I would ask for 50. I think there's there's significant.
I think 30 is a good round number. Like, I think you can make it concise, because I mean, what do you put in there? You don't need to put more evidence in there.
Well, there's an entire analysis. I think the court has to first resolve the tension between state and federal law. There's a subject matter jurisdiction portion that has to be addressed well before the court even gets into the specific charges here, and then the facts as it applies to our client. There's a lot of legal issues that need to be resolved in this case. It's not a simple, here are the facts, here are the crimes.
First 2 things sound very
I don't really know
similar.
that you need to go through the facts.
The
'cause that'll
second
take
one
more than
sounds as
50
a
pages.
subset of the first one.
but,
Come on now,
I mean, if I give you
lawyer.
50, let me get my calculator. 50 times all the defendants. Do you know how much? Do you know how much that is?
I do not envy your position. Go with 300. I understand, but
You want me to read 750 pages of argument?
again, I do not envy your position.
Well, I don't think that 50 pages is necessary.
No, it's not necessary.
Mr.
Sit
Silverthorne.
down. That's the guy I don't like.
I'm going to abide by. the
Whoever
court's
was
ruling.
asking
I'll-
50. That's the guy I don't
will,
like.
Preface my comments with that. However, although this has been one session, the witnesses are testifying are, I assume, virtually identical and may make different statements. And so for the purpose of just raising the objection for the record, I object to not having the transcripts from the other session for that reason, because it is sworn testimony on these material matters that are virtually identical. And if a statement is made that is completely contrary to a statement made, say, in our session, that we don't have, I think that would be relevant to the court's decision. Now, you will have heard it. You will not have heard it.
I'm not using their statements, the information coming from the other as to your client's bind over, because I'm also not gonna let you come in and now decide you're gonna cross-examine in that set of hearings either. You're not getting two bites at the apple. You can place your objection on the record. Good luck to you with that. We're not doing that. This was your time to ask all the questions and get all the information that you wanted in on the record to present your case. You don't get to now wait until I begin another set, and I'm only waiting to give my ruling for there to be one continuous ruling, depending on how this goes. Has nothing to do with me trying to consider what they're presenting as it relates to your client or your client or your client, because that's not what we're doing.
And again, the reason I raise it is because a lot of some of the testimony was defendant specific. The majority of the testimony was case specific.
Doesn't matter. She has to issue all this testimony from scratch for these other people. You're not getting a second bite at the apple.
That's fine. I'm just raising it for the
Thank
record.
you.
Your Honor, Judge, defendant Mary Ann Henry specifically does not join in that objection. I just want clarification. The decision on bind over is going to be, it's going to be focused only on the four corners of everything that was said here.
Absolutely.
We will not be considering any statements.
It will not be considered with anything that comes in with the second set, only what came in on this.
Thank you.
Judge, I again asked for 50, but whatever the court says is what we'll do. Thank you.
Your Honor, would the court be amenable to, because this might even have things go under 30. So for example, if Mr. Stavlin addresses, for example, the law on count one, and we have really nothing to add to that, we would just be repeating that. Would the court be amenable to us saying, for example, we concur with the analysis of the law in Mr. Stavlin's submission, and then, if we believe there's analysis that's applicable to Mr. Haggard?
Who's going to get theirs
I'm
done
just thinking
first?
that might be more time efficient for the court than having to read all these lawyers restating the same law.
I completely agree to that, because if, just as you've done in the courtroom during this proceeding, if one person places the objection, you aren't all repeating that same objection or law applicable, you're joining in. And so to the extent that you all can do that, that would be wonderful, and that would help cut down on the pages. I am going to grant your request for 50 pages, but I'm going to highly encourage you to get it done in less than 50.
Thank you, Judge.
So that's 50 for all?
It's 50 is the max.
Oh my
Okay,
God.
We'll definitely try it.
No, we have 16 pieces.
Oh.
16 briefs.
This is ridiculous.
Thank you. Do you have?
She said all. I was like, wait.
Well, all the
My
defendants.
co-counsel was concerned that we were limited as the people to a single 50-page brief, and I just said, no, that's not my interpretation of it.
You have 16.
So we have 16 cases, so.
Cases, so.
We will use our pages efficiently as well,
Thank
Your
you.
Honor.
Very efficient. Not really so concerned about anybody other than maybe Mr. Danini and Mr. We know they don't want to leave any corners unturned. So with that being said, any additional matters before we adjourn today?
None for the people, Your Honor.
No, are you anticipating argument or just on the briefs?
There will not be any argument, just on the briefs.
Very good.
And then you'll get, after I receive the briefs and when I'm ready to give a ruling, we'll have another date set. But you'll get your dates, your next date
It's not
set after
trial
we
yet.
confirm about when we will get the finished transcripts, because I don't know how long that's gonna take.
Thank you.
And I've seen some of the transcripts so far, so I know you all need time to review them, because I've seen a few boxes of transcripts. I should say, I haven't seen the transcripts.
For the slow ones here, Judge. So you're gonna issue an order. It's gonna be easy.
Correct.
Nothing further. Thank you.
We're all set.
Nothing further. Thank you, Your Honor.
Thank you.
Nothing
You're all
further.
set.
Thank you, Your Honor.
Thank you.
Thank you,
Thank
Your
you.
Honor. Thank you. Now I'm warm. Wow. Okay then. Well, there you go. So just as a reminder, this was it's a very jovial courtroom, isn't it, Kathy? This was the preliminary hearing for this judge to make a determination as to whether or not to bring this to trial. And so that was, this is her opportunity to hear it. And this is just a partial, I think this looked like it was about 4 different whatchamacallits, 4 different defendants of the 16. And I believe we went through this in February with 8. Maybe not totally 8. Maybe we did some in December of 2023 and then some in February. But nonetheless, this was something. Yeah, that's right. Is that still going on, Paul? Is that argument still going on? I'll have to check and see if it is. But yeah, so this was just a preliminary. Let me see if whatchamacallit is happening still. To practice medicine, their freedom. There we go.
Matter of medical reality for many of these conditions, it's not yet putting a woman at the brink of death or necessary to prevent her death, yet they know that the standard of care is to provide her with termination because she is just going to get worse and worse and worse if they wait it out. And the other important point about this, and I think it goes back to this dual stabilization idea, is that tragically in many of these cases, the pregnancy is lost. There's not going to be any way to save that fetus because a woman who has PPROM at 17 weeks, there is no medical way to sustain the pregnancy to give the fetus a chance. So in that situation, what Idaho is doing is waiting for women to wait and deteriorate and suffer the lifelong health consequences with no possible upside for the fetus. It just stacks tragedy upon tragedy.
And it can't be the appropriate, it's become transfer is the appropriate standard of care in Idaho, but it can't be the right standard of care to force somebody onto a helicopter.
And it's entirely inconsistent with what Congress was trying to do in the statute. You know, one of the primary motivators here was to prevent patient dumping. The idea was we don't want people to have to go somewhere else to get their care. You go to the first emergency room in your state and they have to treat you and stabilize you. But this effectively allows states to take any particular treatment they don't want their hospitals to provide and dump those patients out of state. And you can imagine what would happen if every state started to take this approach.
A question on the spending clause, questions that you've been asked. I mean, what would, if you accepted some of these theories, what would the consequences of something like that be that we would have to worry about?
I think that it would call into question any number of federal spending statutes that provide funds to private parties, and there are a bunch of them. You know, there's the Medicare system itself, which is, of course, a major federal spending program. There are funds provided under Title VI, under Title IX, a lot of federal statutes out there that give funds to private parties and insist on conditions of compliance with the federal funding restrictions. And if the court were to suddenly say that can't preempt contrary state law, then I think that it would seriously interfere with the ability of the federal government to get its benefit of the bargain in those spending programs.
And you mentioned before that this question has never been a part of this case.
That's right. They did not make these arguments in the lower court. They briefly referred to the spending clause, but I don't understand them to have pressed this argument specifically. And so I think that the lower courts did not address it. I think the district court said in a footnote, they briefly referred to it in a footnote of their brief, and it's essentially waived.
Thank you.
Justice Kavanaugh? You've touched on what's happening on the ground, and that's an important consideration and answer to the question of what's happening. But Idaho is representing, and I just want to get your answer on this, that, as I counted, 9 conditions that have been identified by the government where EMTALA would require that an abortion be available. An abortion is available under Idaho law, and that's in the reply brief. Now, are there other conditions? You've ruled out mental health. Are there other conditions you would identify, or are you just saying that that's not really happening on the ground? I think that's part of your answer, but I just want to get a fuller answer on that.
It certainly isn't happening on the ground. These are the conditions that we're worried about. And I think the problem with my friend's theory that Idaho law would permit it is that you just can't square it with the text of the statute. You know,
What if they're,
Idaho is,
keep going.
well, I just wanted to say they're not the ultimate authority on what the Idaho law means. That's the Idaho Supreme Court, of course, and it has addressed this issue in the Planned Parenthood case. And I think it's really significant that in Planned Parenthood, the Idaho Supreme Court expressly contrasted this statute with other statutes that contain health-preserving measures and recognized this was a total departure from that. The legislature wanted to focus exclusively and more narrowly on a necessary to prevent death exception. So I think that essentially means that the Supreme Court of Idaho has already touched on this issue, and it's no wonder then that doctors who are facing these kinds of pregnancy complications, where in their medical judgment it's not necessary to prevent death yet, but the woman is going to suffer serious health consequences, their hands are tied and they can't provide that care under the Idaho law.
If what's on page 8 and 9 of the reply brief were Idaho law, would there be a problem still?
So if we had an authoritative Idaho Supreme Court decision that said Idaho law allows for termination in the circumstances where EMTALA would require it, yes, of course, then the conflict goes away. But I can't imagine the court would say that because, of course, here...
That's not quite what 8 and 9 say, but I take your point on that. Separate question, different category. I think one of the themes on the other side is that this law passed in 1986 was a very important law addressing a very important problem, namely the problem where hospitals were turning away poor and uninsured patients who came in for emergency care. And the idea was that can't happen. We can't allow hospitals in this country to turn away poor and uninsured people in emergencies. But their theme is that the law was not designed contextually to deal with abortion or other specific kinds of care. And so they make a textual argument, but I think they also make a broader contextual argument about the whole idea of what was going on in 1986. I want to make sure, I don't think that's really come up too much. I want to make sure you respond to that.
I appreciate having the chance to address that. So at the outset, I don't think they can square that theory with the text of the statute, which says in no uncertain terms, here is the fundamental guarantee. If you have an emergency medical condition and you go to an ER in this country, they have to stabilize you. They have to give you such treatment as may be necessary within reasonable medical probability to ensure that you don't deteriorate. And yes, Congress did not provide a reticulated list of all possible emergency medical conditions and all possible treatments, but it was very clear that Congress set a baseline national standard of care to ensure that no matter where you live in this country, you can't be declined service and the urgent needs of your medical condition addressed. And, it would be no different if the state had come out and decided to ban epinephrine. That's the singular way to treat anaphylaxis, a severe allergic reaction. That would violate the statute, and we would be up here making exactly the same arguments because Congress didn't want that. If you have anaphylaxis and you go to an ER anywhere around this country, they're going to give you epinephrine, and Congress mandated that. And I don't see any way to try to draw lines around to exclude pregnancy complications in the very narrow but tragic circumstances where the only way to address the woman's condition and prevent material deterioration is for the pregnancy to end.
Thank you.
Justice Barrett?
So, General, I understand the primary difference between EMTALA and the Idaho statute to be this health. That Idaho focuses on the risk of life, but the federal government says that EMTALA says that the health is, am I right? It's health and life.
That's the principal difference, but I think that's also the difference between necessary to prevent death versus the health concerns would be reasonably expected to occur. So I think that is a standard that builds in a little more space for doctors to take action.
Got it. Is the federal government aware of any state other than Idaho that has a law that does not take health into account?
There are 6 other states that have severe abortion restrictions without a health exception. So I think that those are the primary category of states we're concerned about here.
Thank you.
I should make clear that there are some pending judicial challenges in those states, and so their laws are not always enforceable or in effect right now.
Besides Texas, has the federal government brought suits similar to the one brought in Idaho and Texas and any of these other states?
To be clear, Texas was not our affirmative litigation. They sued us, but we have not brought affirmative litigation in other states. And I think this case has been on a course, and Idaho's law was particularly severe because at the point at which we sued,
I
it
see
seemed
the
to cover
buffering
ectopic pregnancy,
now.
and the state
Sorry.
conceded that. Now, they have modified the law to exclude that, but it was one of the most pressing concerns because of that.
Thank you.
Justice Jackson?
General, petitioner relies pretty heavily on clear statement rule principles, and I wonder whether you might comment on my thought that those principles actually cut against them in this case. As you said, Congress set a baseline national standard of care. It has said in no uncertain terms that the hospital must provide stabilizing care to people experiencing emergency medical conditions. There was no, as you said, particular conditions or particular treatments talked about, carved out, et cetera. So if a clear statement is required, wouldn't it be the requirement of exempting abortion. I mean, you know, Justice Alito has talked about some of the references to unborn child, but none of them read like an exemption that I would think our clear statement rule would require in a circumstance in which the baseline is this clear national standard of care.
Yes, I agree. I think that Congress clearly was requiring stabilization and made that an unqualified mandate. It wasn't exempting particular conditions or particular type of treatments. And, you know, this court has said that there's no canon of donut holes. That was in Bostock, that when you have a provision like that, the fact that you don't have a specific enumeration of one of its applications doesn't mean that you should read in some kind of implicit exception. So I
and
think
if we're looking for something clear, we would need to see, I would think, the clear statement that Congress meant for you not to have to provide an abortion pursuant to the mandate of providing stabilizing care.
Yes, and I think it's important to recognize that every relevant actor has understood the statute this way from the beginning. They understood Congress's clear mandate here. This has been the agency's position all along. We are not adopting a new position. That's reflected in our enforcement activity and in HHS's guidance and rulemakings in this area. Providers have understood it, even those hospitals that don't provide elective abortions. They have always provided life-sustaining and health-sustaining pregnancy termination consistent with EMTALA. Congress itself recognized it in the Affordable Care Act, and I don't think there's any reasonable argument to be made that people misunderstood what Congress was doing in the statute.
Thank you.
Thank you, counsel. Rebuttal, Mr. Turner?
Thank you, Your Honors. EMTALA takes state law practice of medicine standards as it finds them. As Justice Gorsuch noted, that's what Section 1395 says. And in fact, in the vaccine mandate case that was referenced, that's what the Solicitor General's office told this court when it said that 1395 does not require, does not allow federal officials to dictate particular treatments for particular cases. That's exactly what they are trying to do here with EMTALA. It's also confirmed by subdivision F. That codifies a presumption against preemption. And so to Justice Jackson's colloquy at the end, that is the point. You do presume that state law continues to operate alongside EMTALA. You don't presume the opposite. It's supported by the CMS Operations Manual, which is HHS's Rosetta Stone of EMTALA enforcement. It tells doctors, it tells CMS enforcement agents
Teaches
on the
them a
ground
language? It's
that
a
you consider
software?
what is available
Just
by
kidding.
referencing what is within the scope of that doctor's license. That is exactly what we are saying. It is also specifically
I know what the real
directed in
Rosetta
42
Stone is.
CFR 489.11,
I was just kidding.
which requires hospitals to assure that their medical staff comply with state law. That's a federal regulation that directs hospitals to require their hospital staff to comply with state law. It's also confirmed by the 115,000 enforcement instances that totally lack any theory that would support, any case history that would support the administration's reading. She says that this has always been understood to be the case. Well, you'd think that we would find in those 115,000 instances a single example where state law was overridden by EMTALA, and there isn't one. And finally, the text. The text qualifies EMTALA's stabilization requirement by the staff that is available. We know nurses can't perform open heart surgery, and we know janitors can't draw blood. It's not just a plain mandate devoid of reference to state law.
I know
And we
operating
the
room
word
nurses
available
that
even
can
in
perform
common
open heart
usage
surgery. Okay, if need be.
incorporates state law. For example, you heard just the other day that when considering whether a bed is available for homeless people, it has both a physical sense and a legal sense. And whether cigarettes or alcohol are available to people in Idaho, there is both a physical question and a legal question. Opioids are available in hospitals. They are on the shelf. They are physically there. But there is a legal question that comes into play too. It is the same with abortions. In response to the Chief Justice's question,
No,
on
how in the world
conscience,
is it just like an
Jeremy, you
abortion?
already said that
No,
both hospitals
continue,
and doctors
sir.
are exempt
You
from
fucking
EMTALA's,
idiot.
Supposed abortion mandate. We're relieved to hear that. But I think that it highlights the utter inconsistency of the administration's reading. So if EMTALA's stabilization requirement is general enough not to override extra textual protections like conscience protections, then it cannot be so specific and include a requirement that is in direct conflict with state law. Those two don't jibe. This court does not lightly find a direct conflict. Congress must speak clearly. It has not done so here. The administration's position ultimately
A little
is
bit of a
untethered
gulp
from any
there,
limiting
wasn't
principle. I
there,
think we've heard
sir?
that.
Did you
There's
just
no way
gulp
to
on
limit
some of
this
your
to abortion.
words, sir?
And there's no way to limit it to Idaho. There are 22 states with abortion laws on the books. This isn't going to end with Idaho. It's not going to end with the 6 states that General Prelogger mentioned, because all of the states that have abortion regulations define the health and the emergency
Typically, that's
exception
what SCOTUS is for, where things
than
end,
Idaho does. So this question
right?
is going to come up
So
in
that's
state
actually
after
where
state
things
after state.
end
It's also not limited to
at
physical
SCOTUS.
health. I know
That's the whole
General
point
Prelogger
of
says
SCOTUS.
that there's
Like
no
the entire
circumstance
point
in which a
is that
a
this
mental
is
health
where
condition would
it
require
ends.
stabilization with an abortion. But now she's just fighting
Chad.
with the American Psychiatric Association. The very standards that she's setting up to say controls the EMTALA inquiry. That's not consistent. And it isn't limited to EMTALA. Justice Thomas, Alito, Justice Gorsuch, you all pointed out the major spending clause implications that are at play here. And I disagree that we didn't brief this. It's on pages 20 to 21 of our opening brief. We recognize that this is hugely concerning if the federal government can pay private actors to violate state laws, and not just any state laws, state criminal laws. The implications of that are vast. It leaves the federal government unbound by enumerated powers. And I think General Prelogger admitted that. The court doesn't have to answer that question on our reading. It does on theirs.
Thank you, counsel. The case is submitted.
Whoa.
The
All
honorable
right.
court is now adjourned until tomorrow at 10 o'clock.
Well, there you go. Wow, we just went all over the world. We go everywhere here at Lolo's Lounge. Doot, doot, doot. Thank you, Paul, for calling that out. I forgot about that. I actually assumed at this point in the morning it would have been over. So nice to catch the last part of that argument. So thanks again, Paul. And yeah, wow, what a morning. Woo. I'm ready for a nap. I don't know about you guys. I don't even know what time it is. Oh my gosh, it's just 9 o'clock here. So that means it's lunchtime over on the East Coast when it's Wednesday, which is a special day. It's a good day. Wednesday's a good day. Wednesday's like one of those hopeful days, right? Where you go, oh my God, the week's almost over. Woo! I made it. I made it past Tuesday. Hey, how are you, Paulina? Yay. The lawyer is kind of petty. Yeah, the lawyers on this, yeah, no, it's ridiculous. We've had some ridiculous lawyers this morning, have we not? Have we not, loungers? We've had some ridiculous lawyers with ridiculous arguments. Yeah, thank you very much. Good to see you, Paul. Hope you're doing okay. Yeah, I think that this is like the this is the I think it's going to be like super Fast and Furious now, right? So it's like a Fast and Furious idiocracy. Lots of I really want to find out who that other lawyer, Danini? Is that who she said? I think that's who she was picking on, the judge, and teasing. But I wonder if it's Danini. So I want to kind of look him up and get his story. I don't know who he represents. I can't recall. But I'm interested in that story and just finding out a little bit more about this case. I mean, I have some of the basics, but again, like I said yesterday, I don't really think I understand all the aspects. But it sounds to me like May 28th is the next time we'll have any kind of courtroom drama. Ha, ha, ha. So, yeah, that sounds good. Well, I hope everyone has a wonderful Wednesday. I really do. I hope it's both productive and restful and peaceful. And make peace. Make peace with people. I'm trying. I have lines. And when I draw lines, I draw them. But I'm also very human, and I will, it takes a lot to piss me off. It does actually take a lot. Surprisingly, you wouldn't think it does. But no, it does actually take a lot to push me all the way away. But it does happen. You can push me all the way away. It does happen. But it's pretty tough. You're about an hour from JD. JD. Oh, you're welcome, butterflies. You're welcome. You're welcome. Yeah, have a wonderful day. Make it a good one. All right, so I will see y'all later. And again, thank you for coming. I really am. Again, I know it sounds really dumb when I say it, but I really mean it. Like, just people showing up and saying howdy. And even if you don't, you're just like out there listening in the background. I really appreciate that. So thank you. It means a lot to me. It really does. This would really be nothing without you. I 100% know that, by the way. So thanks again. And I'll see you over on the Twitter lands. Oh, and I'll see you tomorrow morning. Thank you. Thank you, Oomph. I'll see you tomorrow morning at 7 a.m., 10 a.m. Eastern, et cetera, for SCOTUS arguments on immunity. Big, real big. Idaho. Isn't it Idaho? Was I wrong about that? Oh, no. So tomorrow should be a big Supreme Court listen-in tomorrow morning. So don't miss that, because that would be really that's going to be super amazing. Yeah. Wow. We hope in neat coverage. Thanks. Yeah, you're so welcome. Equal health care for all. That's right. Equal health care. That's right. Universal health care. Single payer. Let's do it. Medicare for all. That's right. That's what I believe in. So again, thank you. Sorry, I should just go. I could hang out all day. All right. Bye. I don't know what's playing.